This is all new to me, kind of, sort of. What exactly is a bar member?
A lawyer.
Okay. So
Members of the bar.
Okay, got it.
So, first of all, I'm not a liar. Well, I meant a lawyer. No, I meant a liar. You should never take my word for anything. You should always do your own research. I provided references to aid you in your research, but I don't know everything. So this presentation is going to go through what bar members are, okay? Like the State Bar of Texas, for example, okay? Who they are, where they came from, and what they do. I don't know everything. I'm open to any ideas. I was talking to someone here earlier about the Matrix, and this is a couple shots. I don't know if anybody's who's seen the movie The Matrix. There's 4 types of people you meet in your life. There's the people who try to wake up the slaves. There's the slave masters. There's the people who have no idea they're slaves. And there's the people who like being slaves. Which one are you? Do you really know for sure? Are you who you think you are? If you can see through the illusion, then you are the solution. If the people don't know their basic rights and freedoms, how can they know when or if their rights and freedoms are being infringed? Never forget the men who started this country were marijuana-growing, whiskey-drinking, tax-evading rebels who left their beds at night to shoot at the pigs. All tyranny needs to gain a foothold is for people of good conscience to remain silent. I don't trust the government. I don't trust the medical, pharmaceutical, industrial complex. I don't trust the military industrial complex. I don't trust the mainstream media. I don't trust the bankster criminal cabal that owns the government, owns the medical, pharmaceutical, industrial complex, owns the military industrial complex, and owns the mainstream media. If you call me a conspiracy theorist, then I don't trust you. Government is not reason, it's not eloquence, it is force. Like fire, it's a dangerous servant and a fearful master. A nation that expects to be ignorant and free, if a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be. So who are attorneys? According to former Chief Justice of the U.S. Supreme Court, Earl Warren, between 75 and 90% of all lawyers are either incompetent, dishonest, or both. And I think they're more likely dishonest. Okay? That's why I say I'm not a liar. You got to understand, when a lawyer gets up in court and says anything, he's lying. Okay? Number one, the reason he's lying is he doesn't have any first-hand knowledge of anything. So he's lying just because of that. And so don't get me going. But that's why they're liars. Their lips are moving, they're lying. Any problem you're having, and I call them bar member scum, that's the reason I file bar grievances against them, okay? And I file loads of bar grievances. Matter of fact, I just have a bar grievance against, there's 3 assistant counsel for the Texas Bar Disciplinary Council, the office. There's 3 assistants that have reviewed my bar grievances, and so I just have a bar grievance against them. And I'm getting ready to send it. But so, anyways, and I got a grievance against the chief counsel for the Board of Disciplinary Appeals, too. So, anyways, so we'll see, again, and those ones, I'm going to send to the Supreme Court. I'm going to send it to them, and I don't care what they do with it, because I'm going to send something similar to the Supreme Court, to the Chief Judge of the Supreme Court, and I haven't decided whether it's going to be a nastygram or whether I'm going to be polite. I might be a nastygram and tell them that he's supposed to be regulating these bar member scum, and he's not doing it, and he better get off of his ass and start taking care of business. And the last time I sent something to the Chief Judge of the Supreme Court, he resigned. Okay? So we'll see what happens. Who are attorneys? This is taken from Corpus Juris Secundum, which is a set of books in any law library called Corpus Juris Secundum. There's about 150 volumes. And this is book 7, section 4, attorneys. He is, however, in a sense, an officer of the state with an obligation to the court. That's what an attorney is. His first duty is to the courts and to the public, not to the client. You're paying him how much? He's got no duty to do anything to you. Okay? What do you think these prisons are populated with? They're populated by these bar member scum. Okay? You're going to get me going here. I got to chill out sometimes. I might have to. Hopefully there's other slides in here that kind of, where I can cool off a little bit, because I get going here sometimes. Anyways, his first duty is to the courts and to the public, not to the client. Whenever his duties to his client conflict with those as an officer of the court in the administration of justice, the former must yield to the latter. Clients.
Even if you're paying them?
Huh?
Even if you're paying them?
Absolutely. Absolutely. Oh, it gets better. It gets better. We're only started. We're only started. Clients are called wards of the court. Did you know that when you hire a lawyer, you're saying, I'm an imbecile?
Pretty much.
You are. You are literally saying
You're
that.
just stating, oh my God.
A ward of the court is an infant and persons of unsound mind. A ward of the court is an imbecile. A ward of the court is not competent. Everything is about competence and incompetence. That's why they're representing you, because you're not competent to make decisions for yourself. Therefore, the attorney is going to make the decisions for you. There's no such thing as an incompetent sovereign. Do you know who you are? Black's Law Dictionary, 4th edition. Impropria persona, in one's own proper person. It's a rule in pleading that pleas to the jurisdiction of the court must be pled in propria persona, because if pleaded by attorney, they admit the jurisdiction. As an attorney is an officer of the court, he's presumed to plead after having obtained leave, which admits jurisdiction. If you hire an attorney, you cannot challenge jurisdiction. You give them jurisdiction by hiring an attorney. The controlling rule is that absent a knowing and intelligent waiver, no person may be imprisoned for any offense unless he's represented by counsel. So when you hire an attorney, you're saying, I want to
Put me away.
That's right.
Put me away.
Hey Glenn, that's real important. No person may be in prison for any offense.
That's right. When the trial of a misdemeanor starts, that no imprisonment may be imposed, even though the law permits it, unless the accused is represented by counsel. Okay, now what happens is the prosecutor represents you. Okay? So you might not have a lawyer, but that prosecutor, that's why you bar grade the prosecutor too. You bar grade them all.
So whenever a person gets put in jail, and they say you were, I don't know the wording, but they would give you somebody to represent you, you don't want it.
Absolutely not. Matter of fact, they try and force you to. That's called a star chamber.
Because then that's just a ticket to jail for good.
Exactly.
Why?
They want someone from the state to represent you.
Yeah.
Never do that.
Okay, thank you. I had no idea.
You know, all these bar grievances, what's the typical bar grievance pitch that you have? What's the new normal?
Sorry?
What do you normally say in a bar grievance?
I say a bunch of things.
Yeah.
I've got a lot of material to cover,
Yeah.
and I appreciate the questions. I want questions, but
Everyone's
write it
unique.
down and ask me at the end, because we've got a lot of material to cover, and somebody's coming in and going to be speaking. I've got like 200 slides to go through, and I'm at 19 right now.
There you go.
Okay, so I have some sample bar grievances. There'll be some sample bar grievances under this video on YouTube. So you can go there and read some of them and see the stuff that I bring up. The practice of law cannot be licensed by any state. The practice of law is an occupation of common right. That's the first one's a Supreme Court case, Scher versus Board of Examiners. Okay, so they sit there and they say, well, are you licensed to practice law? Well, so the first answer to that one is that, is he licensed? I want to see his license. because they don't have licenses either. It's a union dues card is what it is. Their bar card is a union dues card. And get a load of this. A retainer is a sum of money paid by a client to secure the attorney's availability to work for the client. The fee paid is considered earned at the time of payment because the attorney is entitled to the money regardless of whether he actually performs any services for the client, and the funds shall not be placed in the attorney's trust account. See, they're just a bunch of thieves. Okay? Don't get me going. You're going to get me going here. Inns of court. This is taken from Black's Law Dictionary, 5th edition. Inns of court, there are certain private unincorporated associations in the nature of collegiate houses located in London and invested with the exclusive privilege of calling men to the bar. Okay, so Inns of court has the exclusive privilege of calling men to the bar. There's an American Inns of Court Foundation. Every state has local Inns of Court chapters. This is the website for the American Inns of Court Foundation. Alexandria, Virginia. I've got exclusive content available on my website. I'm on Patreon. My website has 2 subscription levels, and I accept cryptocurrencies. My basic subscription level is for $29.99 a year. It's a good thing this stuff comes up because it lets me cool off a little bit so I don't get going too much. Anyways, the $49.99 a year for the videos plus unlimited email consultations, but I'm not a liar. Well, I meant an attorney. No, I meant a liar. But I can't tell you what I would do under certain circumstances and where to find the forms. The only power that the New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit, but I cannot fight all the battles. I need other people bringing up the right issues, because that's the problem, is people don't know what's happening. Same with Kerry. Kerry points out what he does, okay? And it's brilliant. Matter of fact, the bar grievances is his idea that I do. Some of my exclusive content, there's an Arlington private information share. I have land deed training. I've got about 3 videos on that. Estoppel certificates training, foreclosure estoppel certificates training, corporate denial training, toll roads notice and demand training, invoice training, notice of void judgment training, revocation of signature training, third-party witness training, federal habeas corpus training, revocation of voter registration, criminal complaint training. There's about 3 videos of that. Lawsuit training, there's 1 video and there's going to be more. And then other training requests if it's something that I can do. Northeast private information share videos. All forms, files, and other instructions are available for free on my videos or on my website. And I have exclusive content available on my website, and you can buy a subscription there. And then I also have the Patreon. So the City of London, remember we were talking about the Inns of Court, right? Well, the City of London is walled in. The Inns of Court is in the City of London. It's walled in approximately 1 to 2 miles square. The Imperial Parliament buildings are located in the City of London. The City of London was never conquered by William the Conqueror in 1066. City of London has several gates, one of which is called Temple Bar. The only true law schools in the world are located in the City of London, and they teach 800 years of jury trial decisions. That's the true law schools. All other law schools teach jurisprudence, okay, which is procedure. There's in the City of London, the Inns of Court there's 4 of these law schools. They're called Inner Temple, Gray's Temple, Middle Temple, and Lincoln's Inn. That's the 4 law schools, the true law schools that are in the City of London. And there's a little map. I actually put this in my book. Most people don't have the courage to share this. This small little country that almost no one has heard about funded all sides of World War I, World War II, and will start World War III if we do not stop them. And that's true. And that's the financial. It's all tied to the Roman cult. We're going to be talking about that. So bar members are actually foreign agents of the Roman cult. City of London is foreign territory to the rest of England. During the convening of the Imperial Parliament, the Queen gives a throne speech. The Queen goes to Temple Bar, which is one of the gates into the City of London. and request permission to enter the foreign territory. She'll go and there's a big oak door, and there's a little 1 square foot door inside the big door, and she'll beat on the door, and the Lord Mayor of London's on the other side. He's the dictator in there. He opens the little door and says, "What do you want?" to the Queen of England. And she requests permission to enter the foreign territory. The Lord Mayor grants permission. The Queen then walks 2 steps behind the Lord, because with her head bowed, while she's in the city of London, she's in a foreign territory. She's not queen there.
That's scary.
Well, that's the law. Most people have no idea how the law works.
So because William the Conqueror conquered all of England except the city of London, everybody in the city of London is not under the Queen.
That's true, but there's no people that live there. It's all Parliament buildings. It's only a couple of miles square, so it's all Parliament buildings and these 4 law schools, and nobody lives there as far as I know. It's all businesses. It's owned by the Roman cult. And here's why, right here. Concessions to England, of England to the Pope, 1213. We will establish a perpetual obligation and concession, and we will establish that from the proper and special revenues of our aforesaid kingdoms, for all the service and customs which we ought to render to them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling. Namely, at the feast of St. Michael, 500 marks, and at Easter, 500 marks. 700 for the Kingdom of England, 300 for the Kingdom of Ireland. Now, a mark, I'm not sure what a mark was. I know a pound was a pound sterling, 1,000 marks sterling. I don't know what a mark was. It was, a pound was a pound. That's a troy pound is 12 ounces of sterling silver. So I've actually got a pound, a coin that's a pound, and it's about this big around, and about that thick, and it's 12 ounces. And but anyways, so that's the concessions of England. So King John agreed to pay tribute to the Pope, and after the concessions of England to the Pope in 1213 was signed, King John had to make money to pay his tribute. King John imposed martial law rule and started to do things to raise money to pay his tribute. It took only 2 years for the people to figure out what was happening, and the Magna Carta was the result. So the Magna Carta was in 1215. This is a Canadian court case. This is Quebec. This is the Magna Carta is not a unilateral act emanating solely from the spontaneous will of the king, as the charters of the predecessors of John. Neither is it a treaty, for we cannot say it was concluded between 2 legitimate and independent sovereignties, nor between 2 nations, nor is it a law. The barons do not appear in it as subjects, for they are freed from their promise of fidelity, and the king, brought captive, placed before them, submitted to the conditions which the conquerors imposed upon him. Magna Carta is therefore a contract, but resembles a treaty concluded between 2 nations, in that one of the parties, in virtue of the law of war, can impose its will upon the other. And that's Perlman versus Pichet and Attorney General of Canada, reference habeas corpus, Quebec. You know, they say that Quebec is civil law, and common law is in Quebec, for sure it is. But they like to make you think that it's civil law. Anyways, so the point being is that they stuck a sword to his throat and they said, "Here, king, we want you to sign this, or we'll run you through right now." And of course he signed it. And this is stuff out of the Magna Carta. The city of London shall have all its ancient liberties and free customs. So they were charging people to come into the city. Free customs. As well as land and water. Furthermore, we decree and grant that all other cities, boroughs, towns, ports shall have their liberties and free customs. And so they were charging people. They were sitting there harassing people at the gate and charging them to come in and all that kind of stuff. No village or individual shall be compelled to make bridges or river banks except those who of old were legally bound to do so. They were forcing people to make bridges and do all sorts of stuff. No sheriff, constable, or coroners or others of our bailiff shall hold pleas of our crown. Think about it. That's what the pigs do on the side of the road, okay? Can I see your driver's license, registration, insurance, please? He wants your plea. Tell it to the judge, okay? So you're basically having to make some basic pleas, and he's taking evidence against you, all this stuff. That's exactly what they do, the cops do on the side of the road today. No constable or other bailiff or shall take corn or other provisions from anyone without immediately tending money therefore. Okay, so they were seizing people's property. No sheriff or bailiff or other person shall take the horses or carts of any freeman for transport duty. So they were taking people's car, saying, well, we need to use your car. And they're taking it. See what I'm saying? Or not in those days, it was their carts and their horses. Neither we nor a bailiff shall take for our castles or for other work of ours wood. They were stealing people's wood. No bailiff for the future shall upon his own unsupported complaint put anyone to his law without credible witnesses. That's exactly what the cop does on the side of the road. He's putting you to his law, and he doesn't even have any witnesses. To none will we sell, to none will we refuse or delay right or justice. These bought and paid for whores are selling their justice in every court case. Yes.
The cops, when they pull you over, they do push themselves around unless you do have witnesses in the court.
Right, right.
And they're totally different.
That's right. That's exactly right.
Yep.
Yeah. Yeah, I was going through, on the way to New Jersey, I went through, it was Maryland, and they got me doing 89 and a 65, eh? And I gave them my Republic of Texas ID card, and I said, I'm a protected person under international law. And 3 of the cops showed up back there, and they came back, and they gave me my ID card back and driver's license and all that stuff, and they said, that stuff hasn't worked in the 70s, but we're just giving you a warning.
Hasn't worked, eh?
Yeah.
Can I say something?
What's that?
Okay, I got pulled over, after all the rain, my tail light was out. And the cop pulled me over, and the woman called and said to me, that was your driver's license and your insurance. So I got it out. I said, why did you pull me over? She goes, you have a tail light out. I'm glad you told me. I had no idea. And so she took my information to her car, and in my console I have light bulbs. Whenever it rains, I got to change out the light bulb. So I rolled the window down. I tried to say she was in the car in the big old church parking lot. And I was like, I have a light bulb, but she wasn't looking at me. So I went to open the door. I'm like, ma'am, and she goes, shut the door. And
Yeah.
she went ballistic
Yeah.
with me. I'm like,
What was it,
I just
was
wanna
it an
show
emergency?
you.
Did she have her lights on?
No.
Well, you didn't need
She had her
stuff.
lights on when she pulled you over?
No, she did do, I don't know if she had the lights on, but she did go whoop. No, she got my attention. So anyway, she walked to my car door and she would never open your car door. I said, I just wanted to show you I have a light bulb. I'm putting it in my light right now. She goes, oh, we don't know if you're gonna pull a gun. I said, I'm trying to show you outside the window and you wouldn't look, so I'm trying to get your attention. I mean, they were into control. It's scary.
Yeah, they're Gestapo thugs. Anyways, the Crown's a corporation that's domiciled in the City of London. The Crown is owned and operated by the Roman cult. The crown that belongs to the Queen has ER transposed over it, stands for Elizabeth Regina. All members of the bar are foreign agents of the Crown. This is the real Article 13 and amendment that was disappeared. It says, if any citizen of the United States shall accept, claim, or receive or retain any title of nobility or honor, or shall without the consent of Congress accept or retain any present pension, office, or emolument of any kind whenever from any emperor, king, prince, or foreign power, the Roman cult's a foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office or of trust or profit under them or either of them. And if you look in the original Constitution, that's how they used to define it. Under them as the federal government or either of them as the state governments. Okay? And so that's the original, that's how they used to define it, and you'll see that in a lot of places. You don't see that anymore because it's all federal dictatorship is what it is. An office of trust is one that requires an oath of office. An office of profit is one which is paid. Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steemit at Sovereignty International. Don't forget to like this video on YouTube. Don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steemit, don't forget to vote and make your comments. Okay. Just checking the stream. Huh.
You need a faster speed connection.
No, that's fine. It's just not showing the whole picture here. I'm not sure why. There we go. Okay, so there's the front page of my channel. The bell or the subscribe button's already clicked. The bell is not clicked. If it was clicked, the arrow's pointing at the bell, it would look like it's vibrating. The War of 1812 was initiated by the Crown to eliminate the true Article 13 Amendment. One of the major engagements was when the British burned the Capitol and the National Archives. The National Archives would have been where the ratification records would have been kept. All bar members have a title of nobility. All bar members have a special privilege or honor from a foreign power. All bar members have an emolument from a foreign power. Title are distinctions by which persons known the statute, the Constitution of the United States forbids the tyrant by the United States or any state of any title of nobility. Titles are bestowed by courtesy on certain officers. The President of the United States sometimes receives the title of Excellency. Judges and members of Congress, that of Honorable. You see these lawyers, okay? And that's all actually tied to the Masons. Honorable members of the bar and justices of the peace are called Esquires. Honorable was a title formerly given to the degree of Fellowcraft, okay? That's the Encyclopedia of Freemasonry. Emolument is a lawful gain or profit which arises from an office, their pay. Perjury, this is the Encyclopedia of Freemasonry, 1916 edition, volume 2, page 555 to 556. Perjury, in municipal law, perjury is defined by the willful false swearing to a material matter. When an oath has been administered by lawful authority, the violation of vows or promissory oaths taken before one who is not legally authorized to administer them, that is to say, one who's not a magistrate, does not involve the crime of perjury. Such as the technical definition of the law, that the moral sense of mankind does not assent to such a doctrine, and considers perjury as the root of the word indicates, the doing of that which one has sworn not to do, or the omitting to do that which he has sworn to do. The old Romans seem to have taken a sensible view of the crime of perjury. Among them, oaths were not often administered, and in general, the promise made under oath had no more binding power in a court of justice than it would have without the oath. So they can lie all day long, and they do. That's Roman law. False swearing was with them a matter of conscience, and the person who was guilty of it was responsible to the deity alone. They sit there and lie. And there's a maxim of Roman law that says, let he who is willing to be deceived be deceived. So they lie and cheat. That's why these judges, it's all tied to Roman law. This is the Masonic Handbook, page 183. Whenever you see any of our signs made by a brother Mason, especially the grand hailing sign of distress, you must always be sure to obey them, even at the risk of your life. If you're on a jury and the defendant is a Mason and makes the grand hailing sign, you must obey it. You must agree with your brother jurors. You must disagree with your brother jurors if necessary, but you must be sure not to bring the Mason guilty, for that would bring disgrace upon our order. You must conceal all crimes of your brother Masons except murder and treason, and these at your option. And should you be summoned as a witness against a brother Mason, be always sure to shield him. Prevaricate, don't tell the truth in this case. Keep his secrets, forget the important points. It may be perjury to do this, true, but you are keeping your obligations. So, again, that's why that bar member is up there calling the judge honorable, right? He's sitting there, it's all Masonic. It's all Satanism. Esquire, a title applied by courtesy to officers of almost every description, to members of the bar and others. In England, it is a title next above that of a gentleman and below a knight. In 1950, the 81st Congress investigated the Lawyers Guild and determined that the Bar Association, by definition, is founded and run by communists. Thus, any elected official that is a member of the bar will only be loyal to the bar entity and never have allegiance to the people. All bar members have renounced their U.S. citizenship as contemplated by the Founding Fathers pursuant to the true Article 13 Amendment. Bar members are here to enforce the martial law. They're all U.S. citizens. Okay, that means District of Columbia. Bar members are in the territorial jurisdiction, and that's the arguments that they're violating Article 1, Section 8, Clause 17. That's the argument. All bar members represent you in court. I don't care if it's the prosecutor. Okay, think about it. You have to think of it this way. Anybody gets up and says anything about you, okay, they're making a legal determination for you, okay? In other words, they're saying, you were speeding, right? Well, in order for him to say you were speeding, he was essentially saying that you're subject to that regulation of the highway, right? And he can't do that without making it's a legal determination. He's saying that you're one that's subject to that rule, and then he can't do that without representing you. So he's representing you without authority is what he's doing. That's exactly what he's doing. That's perjury of oath. And so you have to understand that's what's going on.
But how do you go about saying, I want representation? I'm going to represent myself.
Yeah, well,
How do you get away from
I do it in paper. I file bar grievances. I don't do it in court. If you're in court, it's too late. But you still file bar grievances against them, for sure. And so, if you're hiring an attorney, you're saying you're not competent. If you're hiring an attorney, you're making yourself a ward of the court. If you're hiring an attorney, you're saying that you're an imbecile. The right to be represented exists only in a military court. This is Title 10, Section 838A1. The accused has the right to be represented in his defense before a general or special court-martial or at an investigation under Section 832 of this title as provided in this subsection. They cannot put you in jail unless you have an attorney representing you. When you hire an attorney, you volunteer to go to jail.
Yeah, that's right.
This is U.S. Supreme Court, Arsinger versus Hamlin. We hold that no person may be deprived of his liberty who has been denied the assistance of counsel as guaranteed by the Sixth Amendment. This holding is applicable to all criminal prosecutions, including prosecutions for violations of municipal ordinances. The denial of assistance of counsel will preclude the imposition of a jail sentence. Under the rule we announced today, every judge will know that when the trial of a misdemeanor starts, that no imprisonment may be imposed, even though the local law permits it, unless the accused is represented by counsel.
Wow.
Right?
But do they really truly do that?
He
Do
will-
attorneys know that?
They know it, but you got to argue it, okay? If there's any place where you can be guaranteed to get your rights violated, it's in their so-called court,
Right.
okay? Every time you'll get your rights violated, and the burden's on you to appeal it, because that makes more business for their so-called courts. You know, don't get me going. You're going to get me going here. Anyways, almost all judges are bar members. This is state and federal. This is U.S. code. No individual may be appointed or reappointed to serve as a magistrate judge under this chapter unless he's been at least 5 years a member in good standing at the bar. And then this is Canada, same thing everywhere. No person is eligible to be appointed a judge of a superior court in any province unless, in addition to any other requirements prescribed by law, that person is a barrister or advocate of at least 10 years standing at any bar of any province. Bar members have infiltrated our courts, and they're now found in every organization in the country at the highest levels of government. Did you know that 2/3 of the world's lawyers are in America?
I believe it.
2/3. The leader of every major corporation is either a bar member or they surround themselves with bar members. Bar members have criminally converted citizenship into the opposite of what the Founding Fathers intended. This is U.S. Supreme Court, Colgate versus Harvey. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. And then U.S. versus Rhodes, the amendment reversed and annulled the original policy of the Constitution. So, you got to think about this for a minute. Who are we the people in the preamble of the Constitution? This is one thing that kind of, I can't believe, you see people saying this all the time. We're taxpayers, that's our tax dollars, they have no right to do that. Well, I hate to tell you this, but if you're a taxpayer, you're a slave, you're property, they can do anything they want, okay? And we the people are not taxpayers, okay? We the people are state citizens, right? Who was we the people when the Constitution was written? When the Constitution was written, there was no United States, okay? The Constitution created United States, okay? So when the Constitution was written, the we the people that they're talking about in that Constitution were citizens of Virginia, citizens of Delaware, citizens of New York, okay? They were state citizens. And those state citizens still exist today. You can be a state citizen without being a U.S. citizen. And people that go running around saying, I am a U.S. citizen, that's like saying, I am a slave. That's exactly what you're saying. And people need to understand that. There's so many people that have no idea about citizenship, and I was thinking about next week maybe doing one on citizenship. Because people do not know who they are. And once you know who you are, you have no idea the power you have. And what they do, these bar member scum, because of your ignorance, you go around saying I'm a U.S. citizen, and then they go ahead and sell you into slavery. That's exactly what goes on.
What year was United States versus Rhodes?
That was like around the Civil War time, shortly after, 1870s, 1880s, something like that. The rights of the original citizens of the states as such are not under consideration in the 14th Amendment. They stand as they did before the 14th Amendment and are fully guaranteed under other provisions. Okay, so that means common law. And so that's U.S. versus Anthony. So again, the 14th Amendment does not affect the state citizens, but what it does is it turns everything on its head, okay? Because you go back to here, it says, has the effect of making that citizenship federal government paramount and dominant instead of a derivative and dependent. So under the original Constitution, you had to be a state citizen, and then you would also have, because you were a state citizen, you could also be a U.S. citizen, but the state citizenship was paramount and dominant over the U.S. citizenship. And after, the U.S. citizenship became paramount and dominant, and so now they can just automatically presume you're one of the slaves, okay? Because that's what U.S. citizenship is. I'll show you. There's court cases that talk about it. The only absolute right of a U.S. citizen is to live within the territorial boundaries of the United States. Yes?
My father-in-law, I completely understand where he was in El Paso and moved to New Mexico. It sounds like this is what he followed. He stopped paying his taxes a couple of years and he ended up passing away later, but it's like, giving them their money.
Once you understand the law and how the law works,
Yeah.
it's, it used to be, back in the 30s, that when people came to America, they were given the opportunity, do you want to be a citizen of a state or do you want to be a citizen of the United States? And most of these immigrants were totally clueless about the law and how it worked and said, oh, I want to be a U.S. citizen. And so it used to be, and now they just automatically assault you with their slave is what they do. Anyways, don't get me
So how do
going.
you make yourself just a citizen of the state?
All you have to do is say the words, really.
Just say the
But you can also make it like really powerful by showing that you have ancestors that were here prior to the War of Independence. If you can show you have ancestors that were here, any line of ancestors, then you have by right of blood. And I've got YouTube videos about that. Okay? And so, anyways, now there's a guy by the name of Al Barcroft. Matter of fact, was it Jody? Were you the one that said that you had that book? Oh no, it was the other girl, Tracy, I think.
Yeah.
Said you had that book about the greatest story never told.
Yeah, she's got it.
Right. Anyways, that's written by a guy by the name of Al Barcroft, and he talks about how it's about the Foreign Sovereign Immunity Act. And you're foreign to the United States as a citizen of Texas, or a Texas national is what I prefer to use.
You bet.
And as a Texas national, I'm foreign to the United States, and so you're entitled to Foreign Sovereign Immunity Act protection. You see what I'm saying? And Al Barcroft in his book talks about it. He said that he's seen people of all races claim it because, you know, it's, if you go back in the old court cases, it basically says it's for the white race, but you can, anybody from any race can do it because who knows who was sleeping with who in the 1700s. And you know, he even suggested, and I wouldn't have a problem doing it, I do have ancestors that were here prior to the War of Independence, but even if you could come up with any, you know, you could actually just make it up, quite frankly, because who's going to call you a liar? Somebody has to have first-hand knowledge and make an affidavit and call you a liar. And who's going to do that, you know? Anyways, so
So people that take the U.S. Citizenship class are only becoming citizens of Virginia and Delaware and all those that you just mentioned?
sorry?
So people that take the U.S. Citizenship class to become citizens of the U.S. are only becoming citizens of Virginia and Delaware?
I'm not sure what you're talking about.
Well, you said, it says that we the people, that when the Constitution was written, there was only those states.
Right. Right. Virginia, all of the 13 colonies became states.
And that hasn't been amended to include all the states now.
Well, and that's true, although if you read the act in 1845 when Texas joined the Union, it says in the preamble, it says that Texas has joined the Confederacy. And so there's different schools of thought on how what's proper and what's not proper, but so I think that Texas joined on an equal footing with the original 13 colonies under the Confederacy, whereas other states, like I think that Arizona is actually a territory, and because it joined in 1912, and Congress at the time, when you understand that Congress hasn't been able to do anything legitimate since 1861 because the southern states walked out of Congress, right? And they didn't have a quorum, and Lincoln ordered them back under executive authority. So they haven't done anything legitimate since then. And everything they do is for that unconstitutional corporation. And so I think that the states that joined after that are all territories, really. And yes, Joe?
What does the Foreign Sovereign Immunities Act say briefly?
Well, it basically says that you can claim immunity because you're a foreign sovereign. But it defines, you know, you can't be in any contracts or anything like that. It has some definitions and things. It's not very lengthy. It's in Title 28 U.S. Code.
Is it worth reading?
Sorry?
Is it worth reading?
It's not very long. It wouldn't hurt. It's only like a few pages. Yeah.
Okay, Texas is a republic, and they virtually are their own nation. When did Texas join to be part of the United States. I don't think they ever did they?
Well, and like I was saying, there's some debate about that because
I don't think they
technically,
did.
in order for any sovereign nation to become a part of another sovereign nation, that they have to do a treaty of annexation. And Texas did do a treaty of annexation, and they sent it to the U.S. Senate for approval and adoption, but they didn't. They shelved it. And they did a House Joint Resolution is what they did. Now, and that's not a approval or adoption of a treaty of annexation. And so, but under the Articles of Confederation, it said any other colony could join. You know, there was a formula for joining the Union. Any other colony could join. Now, Texas was not a colony either. And so, I don't think Texas ever did join. But Texas, I can tell you that I've worked in aviation all my life, and the FAA in Texas is completely different than they are anywhere else, eh? And so,
Also, Hawaii never did join either.
Hawaii didn't, that's true. There's the Kingdom of Hawaii, and so there's California Republic. You know, I mean, there's a bunch of stuff that's kind of murky, and I certainly don't know everything. I'm involved with the Republic of Texas. And so, you know, I'm a senator, and so I'm of the opinion that Texas never has joined. But even if it did, you know, the U.S. Constitution is I mean, the founding fathers were brilliant, and they knew the threats, and so they put all sorts of stuff in that Constitution, and that's when I send out my nastygrams, I always rail on these judges, because they're required to know the law, and I just rail on them and call them all sorts of four-letter words and stuff like that, because they're supposed to know the law. They're supposed to know, and so I call it your piece of shit Constitution and your piece of shit statutes that you love to ignore unless you have some political agenda. You know what I mean? And because that's what they do. You know, don't get me going. You're going to get me going. Anyway, so let's keep going here. Bar members have converted a U.S. citizen into a slave. Therefore, U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. A U.S. citizen, upon leaving the District of Columbia, becomes involved in interstate commerce as a resident, does not have the common law right to travel of a citizen of one of the several states. People of a state are entitled to all the rights which formerly belonged to the king by his prerogative. Okay, so we the people, that's the state citizens again, are kings and queens. It will be admitted on all hands that with the exception of the powers granted to the states and the federal government through the constitutions, the people of the several states are unconditionally sovereign within their respective state. And that's U.S. Supreme Court. The state citizen is immune from any and all government attacks and procedure absent contract. Every man is independent of all laws except those prescribed by nature. He's not bound by any institutions formed by his fellow men without his consent.
Question, attacks, government attacks, does that mean physical? I mean, because it's like physical.
If they stop you on the highway, that's an attack.
Okay. Enforcing us to do things against our will.
If the code enforcers come to your house, that's an attack. I don't care what it is. I don't care what it is. And again, there's always a bar member behind it. Okay? Always a bar member behind it. The rights of individuals are restricted only to the extent that they have been voluntarily surrendered by citizenship to the agencies of government. Did you volunteer? I know I didn't. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. Sovereignty itself is, of course, not subject to law, for it is the author and source of law, but in our system, all sovereign powers are delegated to the agencies of government. Sovereignty itself remains with the people, by whom and for whom all government exists and acts. We the people. That's the state citizens, though. That's not the U.S. citizens.
That very first sentence, it does not, state sovereignty does not relate to the law. It's like, exactly.
Yeah. Bar members are facilitating the murder of millions of our unborn children. As used in the 14th Amendment to the United States Constitution, the word person does not include the unborn. That's what the Nazis did with the Jews in the concentration camps. They said, oh, that's okay, they're not persons. So you can go ahead and kill them. How many million children? I mean, the amount of babies that have been murdered makes the 6 million Jews pale in comparison. There's been like 50 million babies that have been murdered.
So bar members have a special obligation under God to protect our unborn, and they're not.
They have a oath to support and defend the Constitution. So they're Satanists is what they are.
Yeah.
And they perjure their oath at the drop of a hat. And that's why you file the bar grievances, and it's a perjury of oath, and you just go after them. The privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. Did you know that? If you say I'm a U.S. citizen, then you don't have access to the first 8 amendments to the Constitution. You're saying I don't want to have access to the first 8 amendments to the Constitution. The only absolute and unqualified right of a United States citizen is to residence within the territorial boundaries of the United States.
Can I ask you another question? I'm going to say yes. When you're sitting there and you have to, they do the oath, do they ask, are you so-and-so, and you're a member of the United States and blah, blah, blah?
I don't know what you're talking
It's
about.
like they've gotcha. If you
I
agree
never
to
tell them I'm a
be-
U.S. citizen. I tell them I'm not a U.S. citizen.
Really?
Absolutely. Absolutely.
Because the common person will say yes. I'm a
I tell them I'm a Texas national,
Okay, good.
but I'm not a U.S. citizen.
Okay,
I do that all the time.
thank you.
I'm a naturalized citizen.
The right to trial by jury.
Hey, Lynn, she's got a question for you. Go ahead.
I'm sorry, I'm a naturalized citizen.
Uh-huh.
What would that make me?
Well, again, what it comes down to is you're naturalized. Where'd you come from?
Venezuela.
Venezuela. Again, it's everything is about what you tell them. Okay, so I wouldn't bring it up. Is what I would do. I wouldn't say anything. Are you married?
Yes.
Is your husband American?
Yes.
Well, then that common law, the wife takes off nationality of the husband. So then you're American. So you get your husband interested in it, and you get him to show his ancestry going back before the War of Independence, and then you have all those same rights and privileges.
Yes.
Absolutely. That's common law,
All right.
for sure.
Thank you.
All right. There's always a way of doing it. The right of trial by jury in civil cases guaranteed by the 7th Amendment and the right to bear arms guaranteed by the 2nd Amendment have been distinctly held not to be privileges and immunities of citizens of the United States guaranteed by the 14th Amendment against abridgment by the states, and in effect the same decision was made in respect to the guarantee against prosecution except by indictment of a grand jury contained in the 5th Amendment, and in respect to the right to be confronted with witnesses contained in the 6th Amendment. So, again, if you're a U.S. citizen, you don't have any rights. The only absolute right of a U.S. citizen is to live within the territorial boundaries of the United States. Right there. Civil rights under the 14th Amendment are for federal citizens, not state citizens. Federal citizens, as parents, have no right to the custody of their infant children except subject to the paramount right of the state. And so, again, if they're stealing your children, again, there's bar members that are behind it. They're assaulting you with that U.S. citizen slave. You go after the bar members. That's who's behind it. It's always bar members are behind it. The term citizen in the United States is analogous to the term subject in the common law. Citizenship is a term of municipal law. Citizenship carries with it the idea of connection or identification with the state and a participation in its functions. As such, implies much more than residence. Residents, as distinguished from citizens, are aliens who are permitted to take up a permanent abode in the country, being bound to the society by reason of their dwelling in it. They are subject to its laws so long as they remain there, and being protected by it, they must defend it, although they do not enjoy all the rights of citizens. They only have certain privileges which the law or custom gives them. Permanent residents are those who have been given the right of perpetual residence. They're a sort of citizen of a less privileged character and are subject to the society without enjoying all its advantages. Their children succeed to the status where the right of perpetual residence given them by the state passes to their children. That's taken from the Law of Nations by Vattel, Book 1, Chapter 19, Section 213, page 87. So again, you don't want to be a resident. One does not necessarily become a non-resident by absconding or absenting himself from his place of abode. The rights of sovereignty extend to all persons and things not privileged that are within the territory. So the key is to stay out of their privileges. They extend to all strangers resident therein, not only to those who are naturalized and to those who are domiciled therein. See, this is as old as time itself. There's always been two classes of citizens. It's talked about in the book of Acts, where Paul said that he was a Roman citizen, and the Roman centurions were scared to death. And in the Old Testament and Leviticus, it says, "Love ye therefore the strangers, for you were strangers in the land of Egypt." That's how they were enslaved in Egypt, because they were strangers. There's the strangers and there's those born in the land. And so when you go and apply for a Social Security number, you're saying, I want to be a stranger. Right? Because they won't give it to you if you don't provide certain things. See what I'm saying? And then after you have it, when you give it out, like for a credit card, okay? In Deuteronomy it says you're not supposed to lend upon usury to your brothers. You can lend upon usury to strangers, right? And so when you fill out a credit card application, they won't give you the credit card unless you put a Social Security number down. And so you got to prove you're a stranger before they'll give you the credit card. See what I'm saying? Lincoln was a bar member. Bar members have facilitated the imposition of martial law rule. Since March 9, 1933, the United States has been a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's taken from U.S. Senate Report number 93-549, dated November 19, 1973. Do you think anything's changed? Absolutely not. Next to revenue itself, the late extensions of the jurisdiction of admiralty are our greatest grievance. The American courts of admiralty seem to be forming by degrees into a system that is to overturn our Constitution and to deprive us of our best inheritance, the laws of the land. It will be thought in England a dangerous innovation if the trial of any matter on land was given to the admiralty. And that's U.S. Supreme Court 1852. It's before the Civil War. Bar members have brought us martial law rule as described in the presentation on martial law. I have a whole nother presentation on that. And this is Revised Code of Washington, Legislative Declaration for Civil Liberties Day of Remembrance. So remember the day when you had civil liberties. The legislature recognizes that on February 19, 1942, the President of the United States issued Executive Order 9066, which authorized military rule over civilian law and lives.
But I just thought a couple slides back when I spoke again, government is not allowed to come into the country and force stuff upon you. What was it that I commented on?
Yeah, well, theoretically they're not allowed to do that, but they do.
Yeah, but I mean, I think they give them permission.
I know.
Just like
Well, it's under executive authority. You have to understand that the president can issue executive orders. It's for government employees. Okay? And anybody with, under Title V, United States Code, Section 552 AA 13, anybody with a social security number is quote-unquote federal personnel.
Right.
And and most of the people are brain dead idiots. They think they have to follow these executive orders. It's really only just for government employees.
What about
And-
corporations?
Huh?
What about corporations?
Well, the same thing. Corporations have to follow it, but no people have to follow it. And that's why I refuse to wear the masks. I refuse to do any of that stuff. And it's a felony. It's a color of law. Okay, that's all color of law. And this is what bar members have brought us. Okay, this is all stuff that bar members have brought us. I mean, I'm only on slide number 80. Okay, I got another 120 slides to go through, and I'm going to go through all the stuff that these bar members are responsible for, and that's why we need to file bar grievances. And yes.
How can you get your paycheck if you don't give them your social security number?
Well, you have to work for, make sure that that's up front, and you got to cash. And I've done it. I did aerospace engineering consulting. I helped design the hydraulic system on the F-35 Joint Strike Fighter, and I didn't have anything taken out of my compensation.
Wow.
I was working in New York. My best paycheck for a week was like $7,700, and it was no deductions. It was all just a check.
Really?
Yeah, but it wasn't made to me. It was made to a company. And then that company filed taxes, and it never paid anything. But
No, they didn't, the company didn't hold you responsible for.
well, I'm the manager of the company,
He owns the company.
and I don't own it. The trust owns it.
Well, okay.
Okay.
So it's all on how you arrange it. But some friends of mine showed me how to do that. But you have to arrange your affairs. Have to arrange your affairs so you can kind of, because everything's with Federal Reserve notes. You know what I mean? I'd rather get gold or silver coin. That's the reason I put it. When I get to that point, I'm very vociferous, and I say that I prefer gold or silver coin, but I can accept a fake money, because the tax is for using the private money system. Okay, you're using their private money. The best you can do with the Federal Reserve note, and we're going to go through it in here. This is thanks to bar members. The best you can do with the Federal Reserve note is discharge debt with limited liability. Okay, you can never. Kerry was right. He said they want me to pay something. So what do you want me to pay? You see what I'm saying? Because you cannot pay anything with the Federal Reserve note. All you can do is discharge debt with limited liability. And the only way you can pay something, and there's a guy that I went and actually, I'm not sure if I made a YouTube video about it, but I certainly made a document from it. But there's a guy that I heard about, and I got his audio thing, where he talks about it, where he went and he'll say to the judge, he'll say, we have a conundrum here. He'll say that there's a problem. We have a conundrum because the value of money is a political question, and he says that under the Constitution, that the only thing you can accept is gold or silver coin, and he says, but under 31 USC, the definition of money is a political question because and you cannot tell me to pay Federal Reserve notes, because that would be perjuring your oath of office there, Judge. And I know you don't want to do that. And you cannot tell me to pay gold or silver coin because there's none in general circulation. And so we have a conundrum here. And he'll say, I think you ought to just dismiss this case. And it got to the point that the prosecutors would actually approach him and say, if you ever have any problems, just let us know and we'll make it go away for you. Anyways, so this is gold or silver coin, but it's not in general circulation. And then a Federal Reserve note, the best you can do is discharge debt with limited liability.
What's the definition of note?
Well, bank note.
Right, but what's the definition of note? It's an instrument that purports to pay a certain amount of money, defined to a certain person, defined at a certain time, correct?
A note can be a lot of different things.
Is a Federal Reserve note, does it meet the legal requirements to be
Oh,
a
I'm
note?
sure, yeah, that's a bank note.
Okay.
Yeah. Anyways,
Are all notes IOUs?
well, there's promissory notes and there's IOUs. It's commercial paper, right? And this is one thing I tell people all the time, is that when I give them a Federal Reserve note, I'll say all I got is this IOU, and they'll kind of laugh, and I'll say, well, it is commercial paper, right? And they'll say, yeah. And then I'll say, well, all commercial paper falls in two categories. It's either a promissory note or an IOU. And a requirement for a promissory note is it has to have a promise to pay. And it used to be, they used to have silver certificates, and it said that you could go get some silver from the Treasury. Okay, so that was a promissory note, because there was a promise to pay on it. But on these ones, there's no promise to pay anything, so it's an IOU. And so then by definition, some guy promised to pay me, and when he pays me, I'll pay you. Anyways, so bar members have brought us color of law. And I've also got some other presentations on it. Corruption in the courts presentation, color of law presentation. Color means a semblance, a simulacrum, as distinguished from that which is real. It's a lie. Color of law is fraud and lies. That's what bar members have brought us. A prima facie or apparent right, hence a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise or a pretext. Colorable means that which is an appearance only and not in reality what it purports to be. Hence counterfeit, feigned, having the appearance of truth. Color of law means the appearance or semblance without the substance of legal right. Misuse of power possessed by virtue of state law made possible only because wrongdoer is clothed with authority of state is action taken under color of law. An unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protection, creates no office. It is in legal contemplation as inoperative as though it had never been passed. Positive law is law actually and specifically adopted by proper authority for the government of an organized juror society. And an absolute nullity is an act that is void because it's against public policy, law, or order. The nullity is incurable. It may be invoked by any party or by the court.
Is that positive law a statute then? Is that what that's defined?
Some statutes are positive law. They're enacted as positive law,
Legislature.
but what happens is like Title 26, like Kerry was saying, is not positive law. But again, you have to understand that the way it works is that they don't. It's basically a regulation. But
the underlying of proper authority got me thinking legislature.
yeah, there's no proper authority. But bottom line though is that if you're a U.S. citizen and they have reason to believe you are, otherwise they wouldn't be talking to you. Okay, you've made statements. I swear under penalty of perjury, I'm a U.S. citizen. You see what I'm saying? And if you have a Social Security number or have given them one, then that's another reason why they have reason to believe you're one of the slaves, government employee. You see what I'm saying? And so when you start giving that kind of evidence out because of your ignorance, then that's when they come after you. Okay, because they don't need positive law for their slaves.
But then if you don't deny it, but you don't answer it, I mean, can't they get you for
Right.
the?
That's what he talks about. And so that's why you better answer.
But as soon as you answered, they got you.
Not necessarily. I mean, they didn't have him, did they?
Well,
I appreciate you asking.
Well,
What are you really talking about? I'm confused. That's an answer. Right?
There you go. Yeah, that's right.
I have a question for you. If you have a bank account, you're required to give your Social Security number.
I know.
Okay. Now, how do you get out of that?
You can. There's actually Bank of America. Actually, Bank of America doesn't require a Social Security number. I know that some people in some states.
They do, but you just keep telling them I'm not giving it, and then they'll give
Huh?
you. Bank of America will tell you got to have it first, but you keep telling them I don't have to give it to you.
Well, that may be your experience. I know that Al Barcroft, that did that book, The Greatest Story Never Told, actually sued the Bank of America, and they settled with them over compelling a Social Security number because they cannot compel it. But again, most people just cave in. And if they ask and you give it to them, then you gave it to them. You give evidence against yourself. And what happened is I give them their ID. I gave them a passport back when I opened the account. I don't even have a current passport now. But the point is that you know, first of all, you have to understand that what's the bank have? It has Federal Reserve notes. Okay, they don't have any lawful money. I've been in lots of banks and I asked them, do you have any of these? And I'll pull out my Silver Eagles, right? And they'll say, no, we don't have any of those here. And I'll say, well, then you're technically bankrupt, aren't you? Because you don't have any money here. And so, you know, I like to talk to them about that kind of stuff. Anyway, so the point is that they're dealing with the negotiable instruments, the commercial paper, and we'll show the Gold Reserve Act of 1934 that says that Federal Reserve notes are meant for internal use of the government only. So if you have Federal Reserve notes, then I guess you're a government employee. And these city pigs go and assault you, and they want Federal Reserve notes, so they're dealing with their government employees again. And so, you know, it's because we the people have been asleep at the wheel for so long, and it's to the point now they just assume everybody is one of the slaves. You see what I'm saying? And so, you know, that's really what it comes down to. But so I can tell you that I opened a bank account with Bank of America, and I didn't have any trouble at all. And they actually harassed me every once in a while. I have an app on my phone for Bank of America, and they come up and say, want to verify your. And I called them up one time, and I started reading the Riot Act, and I said, you guys are involved in war crimes under the Geneva Convention of Protection of Civilians in 1945, and I said, Article, I think, 39 says that you can't coerce information from me. And they immediately came back and said, we do not require a Social Security number.
But the common person doesn't know the feet on that
They
stuff.
don't.
I mean, it's like,
Well, they back us into a corner. It says, are you a U.S. citizen? It doesn't say, are you a U.S. citizen or an American national or a state citizen? It's you're either a U.S. citizen or you're from Japan, right? They back us into a corner. You don't have any choice, and you can't tell the truth. They don't want you to tell the truth.
That's the thing, is it's lawyers that are behind this. They lay awake at night with this stuff, okay? And that's why you go after the bar member scum. For the very idea that one may be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another, gee, that sounds like taxes, seems intolerable in any free country where freedom prevails as being the essence of slavery itself. Well, gee, I guess we're all slaves here because people put up with that all the time.
Well, yeah, I'd like to point out, this lady here, you said so-and-so, he didn't pay his taxes. Right. You have an assumption he owes a tax.
No.
He didn't pay his taxes.
right.
Okay, how do you know that they were his?
Right.
I mean,
right.
they back everybody.
Maybe he
They'll-
didn't have
they'll
any
tell the
taxes.
Jury, because he didn't pay his taxes, presumption that he lawfully owed these taxes, you have to pay more. And they make the jury a party to the action. And the judge sits right there and says, nothing about it.
Right, of course, the judge sits there and plays stupid.
Well, whenever they ask you, United States citizen, it's like, no, I'm a Texas nationalist, what do you say?
Right,
Okay,
They
say
won't
that.
Right there.
respect it.
Okay,
yeah. I'm not, matter of fact, that's the first thing you can do to get kicked off a jury. Say, I'm not a U.S. citizen, but I'm a Texas national. Oh, well, you're released.
okay, good.
Anyways, but it might be good to be on there, and so that you could educate some jurors too. But the subpoena is in form and official command, even though improvidently issued, it was some coercive tendency. This is color of law. Either because of ignorance on their rights on the part of those whom it purports to command, or their natural respect for what appears to be an official command, or because of their reluctance to test the subpoena's validity by litigation. And that's U.S. Supreme Court, U.S. versus Minker. Now there's a summary, but this is all color of law again. They're talking about color of law. Because of their respect for what appears to be a law, many people are cunningly coerced into waiving their rights due to ignorance.
That was 1956.
Exactly. That's exactly
Oh, that's a
what
good
goes
one.
on. Yeah. But that's not the actual site. That's a summary of what that case says. The actual site is right here. But the courts are not going to come out and say that kind of thing. You know what I mean?
Right, well, that's exactly what they're saying.
My contact information, my blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile is Sovereign Living. My Facebook community page is deleted due to censorship on the part of Facebook. My private group, Sovereignty International, is being deleted. I haven't been to Facebook in months, and Facebook is a has-been. My private group, I have a private group at Freelist and Google. Both of them are called Administrating-Your-Public-Servants. Follow me on Steemit at Sovereignty International. I have a library profile and a Patreon and a MeWe group.
Can you read that up for a minute? Just talk about now.
The code is only prima facie evidence of the laws of the United States. Where an inconsistency between the United States Code and the statute at large appears, the statutes at large prevail over the code. In other words, all codes are color of law. If they're not positive law, then it's color of law. So, remember Kerry was talking about Title 1? Okay, that's color of law. Title 26 is color of law. It looks like law, acts like law, but it's not. It is well settled that the code cannot prevail over the statutes at large when the two are inconsistent. The provisions of the code are merely prima facie evidence of the law. At first look, that's what prima facie means. A code is the interpretation of the statutes at large made by bar member scum. So, I mean, really, that's what it is. So, bar member scum, read the statutes at large and put it in a code.
Glenn, is it true that BAR stands for British Accredited Registry?
Huh?
Is it true that BAR stands for British Accredited Registry?
It's Regency, actually.
Regency.
British Accredited Regency, because that bar member is playing regent, okay? Because we're all kings and queens, right?
Hey, Glenn.
So he's being a regent for you. What?
1 second, we gotta go,
Okay.
but I just wanna tell everybody where we're going.
Where you going?
Keith is, from Montana.
Yeah.
We met in Twin Joint Nation Group, he's lost his kids the way I did,
Oh, wow.
so we've been friends for a long time. One of our peer advocates just lost her husband Wednesday, because he took the jab.
Oh, you're kidding.
Took his first on the 19th, on the 25th he was dead from the second.
I hope you guys haven't taken
Granddaughter
it.
was born the day before.
Good.
Don't take anything
How
more.
long?
No joke.
We're going to that funeral.
How long after the shot? Huh?
6 days.
So predictable. Don't take those. No shit.
Did you see that YouTube video? The guy that took the jab walks up to a TV and the Bluetooth comes on, and it picks up his jab, eh?
What?
Yeah, I'm serious. It was a YouTube video. He got to like within the distance that I'm with that TV, and the Bluetooth comes on and it says searching for, and it named it. It was like, what's the name of some of those pharmaceutical companies?
You are
It wasn't Moderna. It was one of the other ones, but it was one of the
You are
ones.
Pfizer. You are-
Whatever, yeah.
whatever.
It said
You are J&J.
it said searching found this
Trying to connect.
trying to connect. That's
Trying to
right.
connect.
That's
You
right.
are
And
screwed.
his
You
phone was trying to do it all the time too. Anyways, Congress claiming its martial law power to declare war, suppress insurrections, and repel invasions, imposed martial law in the United States and never discontinued it. The result was an extension of the military and municipal jurisdiction of Congress, but where's the evidence of this? Look at the 13th Amendment, the Civil Rights Act, the legal tender laws, the 14th Amendment, etc., etc., etc. And this is taken from non-ratification of the 14th Amendment by Judge A.H. Ellett of the Utah Supreme Court in the case Diet versus Turner. It's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session, June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental officers and departments, and is further evidence that the United States federal government exists today in name only.
Jude, would you go back to that slide,
Go back one slide.
the one you just read?
Okay.
Maybe.
If you want, send me an email. I'll send you a PDF of this presentation.
Yeah. I'm not-
Okay, what's your reason?
Um,
You have something there. Okay. One of these documents, this is sovereign international.
Yeah.
Okay.
Say, Glenn, you're gonna go through all 200 slides?
sorry?
Are you gonna go through all 200 slides?
Yeah, hopefully if we get
I'm
to.
gonna order some food, I'll be right back.
This is Dun & Bradstreet's website, shows United States of America 4 court. Okay, so I guess we're on number 4. At least that was back when this was printed. It doesn't have a date there. But there's a lot of these corporations that have been set up. The 14th Amendment is an extension of national military powers presently used in municipal character and enforced by municipal laws, stretch far beyond their original limitation and enforced by Article 1 tribunals. Remember, last week we talked about how I use Article 1, Section 8, Clause 17. And that says that the District of Columbia is only 10 square miles over there between Virginia and Maryland. And that's what all of these courts are, District of Columbia courts. And that's, again, that book is actually available on my website. I highly recommend you ought to get it. And it's not a difficult read. It's about 100 pages. And it's double spaced, so it's a quick read. It's got all sorts of little nuggets in there. Check out my other videos, Bankster Thieves Playlist, Roman Cult Playlist, Bankrupt Corporate So-Called Governments, Bar Members 1 through 7, Do-It-Yourself How Not to Volunteer for the Selective Service in the Draft, Martial Laws Here, Do-It-Yourself No Income Tax, Do-It-Yourself Free Mail, Do-It-Yourself Kangaroo Courts 1 through 19, Canada Border Pigs Playlist, Bar Members and their Satanic Connections Playlist.
Is that bar members, is that throughout the United States? I take it, my uncle is an attorney in Louisiana. I think he was really shocked to hear this.
The bar is all over the world.
I know,
It's
but it's like,
written.
like I said, my uncle, it's like,
It's a union, basically. They don't want this out. You realize that we're the worst getting this information out. It's bar members.
It's beyond that.
More and more people realize
No.
that.
It's good.
I'm in.
Okay, so we'll keep moving here. Tribunals come from canon law in the Vatican. Tribunals are military courts. There's canon law, and they talk about tribunals, different grades and kinds of tribunals. It all comes from the Roman cult. This is another thing taken from non-ratification of the 14th Amendment by that Judge H. Ellett. He says, as we have said, the federal personal income tax is collected under a military venue within the martial law jurisdiction. Federal Reserve notes are military script circulated within a military venue. The problem is the people don't understand how the entire United States is covered by a military venue. Under the Social Security Act that was brought into existence, 10 federal regional areas. These 10 federal regional areas are the same as a military base. It's not unconstitutional to circulate military script on a military base, as the base is considered to be a military venue. Military script cannot circulate in the civil jurisdiction of the several states. To get around this constitutional bar, the Congress, via the Social Security Act, created 10 military venues called federal regional areas. The problem the Congress realized was, while Congress could restructure the government agencies into these 10 federal regional areas, the people could not be identified to be within this military venue but by their own consent.
Exactly, they got to consent.
You gotta consent. The solution was to create another military venue which would trick the people to voluntarily, this is what these bar member scum do, they lay awake at night, this stuff. Trick the people to voluntarily accept recognition that they're within a military venue. Congress solved this problem by creating a zip code. The zip code divides the United States into 10 military venues called national areas. When a citizen receives mail from an agency of the federal government, such as the IRS, and the return address of the federal agency is the district within the regional area the letter is sent from, and on the address of the citizen it was sent to is the national area in which he received correspondence from the IRS. In other words, the correspondence was sent from one federal regional areas, a military venue, to one of the national areas, another military venue. Taxing districts are established within one of the federal regional areas, which places the collection of taxes under a martial law jurisdiction.
Well, how do you get away from the zip code?
Zip code exempt. I do it all the time.
Okay, so
I do free mail too.
you can do your address.
I do 3-cent mail,
So if somebody wants to send you.
3 cents per half ounce. I don't pay 50 cents for a letter, I pay 3 cents. And you can get 3-cent stamps from the post office all day long, all sorts of them.
No letters, no,
Yep.
and they won't have a problem. with
Well,
it.
you gotta put on there, I put something on the envelope to make sure that they're held accountable, but they get there no problem. I have a friend of mine from West Virginia that showed me how to do it.
Would you bring a sample for us to see next time?
Sure,
Thank you.
sure. All U.S. courts are territorial. The United States District Court is not a true United States court established under Article 3, under Constitution Article 3, to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3 of the making all needful rules and regulations respecting a territory belonging to the United States. And that's U.S. Supreme Court again. Balzac versus people of Puerto Rico. So no United States, all United States federal courts are actually territorial. In other words, when state martial law is imposed within a state to enforce national martial law, Congress has no reason to exercise its martial law powers. If a state has conformed to the new order, there is no need for Congress to intervene. And if citizen has not obtained the standing of a former slave by petitioning Congress for admittance to venue and jurisdiction of the 14th Amendment, then Congress has no power over that individual under this clause.
So they have no right to do martial law.
No, they coerce you into it. When a state forms a constitution which is approved by Congress, it is a stop to deny its validity. The action of Congress cannot be inquired into, for the judicial is bound to follow the action of the political department. That's U.S. Supreme Court, 1849.
What is that?
Huh?
What does it mean?
Well, the question is there any separation of powers? Think about it. That was in 1849. That was before the Civil War.
Right.
And now, this is Rule 45 of the Supreme Court. It says all process of this court issues in the name of the President of the United States.
Right.
I submit that there is no separation of powers. You basically have a dictatorship. But again, if you're a U.S. citizens don't have any rights. We already went through that one. Over the years, the people have had great deal of trouble accessing the judicial power of the courts. Since martial law suspends the judicial power along with other regular powers of government, this is quite understandable. Congress's powers is practically speaking unlimited, where the regulation of courts subjected to martial law rule are concerned. Therefore, why would Congress think that their power over the martial law measures in general is limited to the Constitution, especially since Congress claimed power under martial law with the power clauses of the 13th, 14th, and 15th Amendments? It never became a law and was as much a nullity as if it had been the act or declaration of an unauthorized assemblage of individuals. And that's really what happens. Okay, they're not laws. They're color of law. It's all color of law. And this is all thanks to bar members. Okay? These bar member scum are responsible for all of this stuff.
It's just the way it's always been done, so people like to accept it, and it's the way it is.
Well, that's the excuse they have, isn't it?
Exactly.
Under the Lateran Pact of 1929, Italy agrees to give the Vatican all the rights of a sovereign nation and protect the Vatican. Canada, United States, and most other nations have signed on to the Lateran Pact. Under the Lateran Pact, the Vatican is considered neutral territory. All courts in Canada, United States, are United Nations courts under the Unidroit Treaty, and have been for over 30 years. All courts are de facto courts. There is no authority to delegate anything to the United Nations in the Constitution for the United States of America or the British North America Act, which is the Constitution of Canada. Unidroit stands for the Unification of Private Law, and the website says that 63 countries have adopted it, and it's designed to be automatically implemented. Canada and the United States have been signatories to the Unidroit Treaty for over 30 years. Unidroit website says nothing about Texas, Arizona, or any of the American states or the Canadian provinces. Therefore, the Unidroit application to the American states and the Canadian provinces is only federal areas. Think about it. And Unidroit controls the Uniform Commercial Code. Under Unidroit, it covers negotiable instruments, civil procedure, as in the courts, right? Civil procedure, civil liability, secured transactions, maintenance obligations, legal status of women, banking law, contracts, transportation, hotels, leasing. Insurance, anything related to marriage, divorce, children, municipal law. And remember last week we talked about how all courts are DC courts, and then we talked about how Roman law, Roman civil law, and civil law are convertible phrases and mean the same thing, and are really talking about municipal law. And so this word municipal law is covered by Unidroit. Canada, United States, there's 63 countries that have signed on to the Unidroit Treaty.
However, Texas is not of it. Do anything they're not.
Oh, I know they're not, but there is a Texas Business and Commerce Code. But you have to understand that that's all tied to the Unidroit Treaty, and that's the federal. Okay, that's federal jurisdiction, not state jurisdiction.
Texas is not that.
Anything involving motor vehicles or the courts is both commercial and federal.
And therefore not, so we are not required to take care of that?
That's why you tell them one page. Article 1, Section 8, Clause 17, I'm not a U.S. citizen, but I am a Texas national, and then vacate this citation and sign it under penalty of perjury.
And you won't have some yahoo saying, but you've got to do it and call the cops over and...
Well, that's what you file into the court, actually, and the case will disappear. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways and the transportation of passengers or property or cargo. And so that's Title 18, United States Code, Section 31. The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business or other undertaking intended for profit. So again, if you're not doing that with your car, then you don't have a motor vehicle.
Well, but you know, you're going to have passengers in the car, you got to put gas in it.
If they don't pay you for it.
Are you charging them?
No, but that's my right to travel.
So then they're guests. They're not passengers, they're guests. It's true. Anything in America, Canada, United States, or federal and state involving motor vehicles or the courts or the banks or finance is actually federal and falls under Unidroit. Unidroit is private international law. It's all international law. Governments are but trustees acting under derived authority and have no power to delegate what's not delegated to them. but the people as the original fountain might take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people of that state, okay? It's not U.S. citizens, it's the state nationals.
And Texas is the strongest state. I mean, we're the ones that, I mean, other states, maybe Oklahoma a little bit.
Well, they're all, well, it's hard to say about Oklahoma. I'm not sure when they were supposed to become a state. But I can tell you that the certainly Texas, I think, is on equal footing with the original 13 states. And Texas really, it's hard to say whether Texas is really part of the United States anyways.
No, they're not.
But anyways, there is no such thing as a power of inherent sovereignty in the government of the United States. In this country, sovereignty resides in the people, and Congress can exercise no power which they have not by their Constitution entrusted to it. All else is withheld. A delegate cannot delegate, an agent cannot delegate his functions to a subagent without knowledge or consent of the principal. The person to whom an office or duty is delegated cannot lawfully devolve the duty on another unless he be expressly authorized to do so. A delegated power cannot again be delegated. A deputy cannot have or appoint a deputy. There is no delegated authority for a corporation called United States or any agency, department, commission, board, or other entity of such corporation. And this is 28 U.S.C. Section 3002. As used in this chapter, United States means a federal corporation. So there's no delegated authority for that. There's no delegated.
What was the citation on that?
28 U.S.C. 3002.
8 U.S.C. 3002.
There's no delegated authority for a corporation called Federal Bureau of Investigation, National Security Agency, Central Intelligence Agency, Department of Homeland Security, Internal Revenue Service, Department of the Treasury, or an agency called the Office of Attorney General of the United States.
People just accepted it. They say it and we just accept it.
Ignorance. There's no delegation authority for a municipal corporation called City of Fort Worth or City of Grand Prairie. Any municipal corporation, any prison corporation, a corporation called Department of Public Safety in any state, a corporation called Texas State Police or State Police in any state. The word Canada, as used in Section 91(1) of the Constitution Act, does not refer to Canada as a geographical unit, but refers to the juristic federal unit.
We have a completely phony government.
The usual form of juristic person, and the only one at common law, is a corporation. So it's all corporations. In Canada, there's no authority for a corporation called Canada or a corporation called Royal Canadian Mounted Police or Canada Border Services Agency or Lethbridge Correctional Center or Calgary Remand Center or City of Calgary, City of Lethbridge, any of that. It's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent, HJR 192, 73rd Congress, in session June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments, and is further evidence that the United States federal government exists today in name only.
Roosevelt was evil.
He was.
So how does all this information help us?
Well, I'm just going through what bar members are doing, okay? So we need to know that bar members, everything, it's like I said right at the very beginning, that bar members are responsible. If there's any problem you're having with the government or with any corporation for that matter, there's always a bar member behind it.
Knowledge is power.
This is taken from the Congressional Record, March 17, 1933. This is Canada. This is the instruction sheet for a social insurance number. And it says there in paragraph D, if you're replacing your SIM card, you must pay $10. Make your personal check, bank draft, or money order payable in Canadian funds to the Receiver General for Canada. Well, think about that. That's the receiver in bankruptcy. So, Canadian government's bankrupt too. When any corporation goes bankrupt, the creditors become the owners. It's a coup d'etat for the government, except they don't tell you. Think about it. They get new owners. And this is AMR creditors prefer all stock merger with U.S. Airways. And then we're going to get in closer to this. It says, as new owners of a significant percentage of the restructured airline, it's APA's responsibility to maximize the value of our investment by conducting thorough due diligence. And it goes on, it says here, under the U.S. Airways proposal sent in November, AMR creditors would own 70% and U.S. Airways shareholders 30% of the merged airline, which could be valued at around $8.5 billion, sources told Reuters on Friday. So again, any corporation goes bankrupt, the creditors become the owners. Yielding and paying yearly to us, our heirs and successors, for the same the yearly rent of 20 marks of lawful money of England at the Feast of All Saints, yearly forever. The first payment thereof to begin to be made on the Feast of All Saints, which shall be in the year of our Lord 1665. And also the fourth part of all gold and silver ore, which within the limits of aforesaid shall from time to time happen to be found. And that's found in the Carolina Charter of 1663. Now, if you look at the map, and I don't think I have that map here, but I have it in other presentations, the Carolina Charter originally went from coast to coast. So they're talking a fourth part of all gold and silver. Damn. Forever. And further, provided further that nothing herein contained shall affect the titles or possessions of individuals holding or claiming under the laws heretofore in force or grants heretofore made by the late King George II or his predecessors or the late Lords Proprietors or any of them. That's the Declaration of Rights, 1776, North Carolina Constitution. That's after the Declaration of Independence. In Tarrant versus Taylor, it was stated that the dissolution of the regal government no more destroyed the rights of the church to possess and enjoy the property which belonged to it than it did the right of any other corporation or individual to his or its own property. In the later case, the Chief Justice, in reference to the corporation of the college, observes that it is too clear to require the support of argument that all contracts and rights respecting property remain unchanged by the Revolution, and the same sentiment was enforced more at length by the other judge who noticed this point in the cause. So again, that's the Society and etc. versus the town of New Haven, 8 wheat, so that's like around the War of Independence. There's no authority in Canada or the United States to delegate any power to the United Nations or any United Nations agency. Ultra vires, Black's Law Dictionary, 6th edition. An act performed without any authority to act on the subject. The term has a broad application and includes not only acts prohibited by the Charter, but acts which are in excess of powers granted, and not prohibited and generally applied either when a corporation has no power whatever to do an act. Act is ultra vires when corporation is without authority to perform it under any circumstances or for any purpose. Ultra vires act of municipality is one which is beyond powers conferred upon it by law. And so they're acting, all of their acts are ultra vires, right? They're all municipal corporations and they're engaging in acts that are ultra vires. Obedience to de facto law. No person, this is Canada, no person shall be convicted of an offense in respect of an act or omission in obedience to laws for the time being made and enforced by persons in de facto possession of the sovereign power in and over the place where the act or omission occurs. You know, and these scumbag bar members lay awake at night dreaming this stuff up. We, as these United States bankster thieves, make all the rules, insurance, negotiable instruments, banking, etc. These United States bankster thieves make it mandatory so they can create a fictitious debt. By fraud, these United Nations bankster thieves create a cestacate trust in the name of every living soul when they are given birth to use to finance their fictitious debt and to facilitate the slavery of we the people. These United States Nations bankster thieves then seize the corporation when it inevitably goes bankrupt and thereby create their worldwide dictatorship. These United Nations bankster thieves get their whore buddies in the bankrupt legislatures and parliaments who sold themselves to the bankster thieves to hire low intelligence pigs to populate border crossings so they can assault people, kidnap people, falsely imprison people, create business for their so-called courts to generate business for their bankster owned and operated prisons, and generate revenue to support the fictitious debt. Okay, that's exactly what's going on. Everybody that's in prison was sold into slavery. There's a designation, there's a distinction between a debt discharged and one paid. When discharged, the debt still exists, though divested of its character as a legal obligation during the operation of a discharge. Discharge falls under the law of nations, which is international law. These banksters, these bar member scum lay awake at night with this stuff. The action of Congress in the passage of the first Legal Tender Act was placed distinctly on the ground of the existing imperative need of government, and the Legal Tender Clause was urged and adopted as a war measure. At common law, only gold or silver were legal tender. If you want common law, it requires honest measures. Copies of these documents can be found on my website, linked under my recent videos. For a complete set of YouTube videos with private information shares, a DVD with over 50 searchable law dictionaries, and other books and forms, contact me privately at engineerwin@yahoo.com. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept the IOUs, the fake money, the military script, the Federal Reserve notes, the PayPal gifts, the checks, the money orders. Send me an email for particulars. As used in this act, the term United States means government of the United States. The term currency of the United States means currency, which is legal tender in the United States and includes United States notes and Federal Reserve notes. And so the Federal Reserve notes are meant for internal use of the government only. This is taken from the Gold Reserve Act of 1934 at 48 Stat 337. And there is a District of Columbia court. They're all District of Columbia courts. These are bar member scum. They screen their pigs for low intelligence. There's court cases that talk about it. And so these bar member scum want these low intelligence thugs running around, give them guns so they can go out and assault people, make business for their so-called courts. The judge works for the state, the prosecutor works for the state, the police works for the state. The vast majority of the disputes that the police initiate on behalf of their employer are also adjudicated by their employer, where the plaintiff, the judge, the antagonist, the police, and the only witness, also the police, all represent the same party. And so since no corpus delicti, mens rea, or acts reus can be produced, doesn't technically qualify to be heard according to its own laws. The state, therefore, is indistinguishable from a criminal cartel. Whenever the Texas Business and Commerce Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports the finding of its non-existence. And that's Texas Business and Commerce Code, which is equivalent to the Uniform Commercial Code 1.206. And this is 3.308, Texas Business and Commerce Code. In an action with respect to an instrument, the authenticity of and authority to make each signature on the instrument are admitted unless specifically denied in the pleadings. So what they do is they forge your signature onto a contract and then they sell you into slavery. That's exactly what they do. This is 8.114 in the Texas Business and Commerce Code. The following rules apply in an action on a certificated security against the issuer unless specifically denied in the pleadings. Each signature on a security certificate or in a necessary endorsement is admitted. So they forge your signature onto a contract and sell you into slavery. It's exactly what they're doing. The judge wears a military uniform. The judge sits there and plays stupid. If you fail to follow some obscure rule or procedure, they sell you into slavery. Everything they do is a fraud and a nullity. When acting to enforce a statute and the subsequent amendments to the present date, the judge of municipal court is acting as administrative officer, not in a judicial capacity. Courts administrating and enforcing statutes do not act judicially, but merely ministerially. They're bought and paid for clerks. It's the accepted rule not only in state courts but of the federal courts as well that when a judge is enforcing administrative law, they are mere extensions of the agency for superior reviewing purposes as a bought and paid for clerk. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, act as mere clerks for the involved agency. Remember, we were talking about that last week with all these DC courts. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Where there's no jurisdiction, there's no judge. The proceeding is as nothing. Such has been the law from the days of Marshal Saya. So again, it's not a court. Okay, they're DC courts. It's a kangaroo court. It's not a court. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in a catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia through their plenary power, that's military dictatorship, nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And all these people are running around saying, oh, I'm a U.S. citizen. International law rule adopted for federal areas under federal legislative jurisdiction. Federalizes state civil law, including common law. Rule serves to federalize not only statutory, but the common law of a state. State and federal venue discussed. Civil laws effective in an area of exclusive federal jurisdiction are federal law, notwithstanding their derivation from state laws. And a cause arising under such laws may be brought in or removed to federal district court. That's taken from Jurisdiction over Federal Areas Within the States, report of the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas Within the States, Part 2, a text of the Law of Legislative Jurisdiction submitted to the Attorney General and transmitted to the President June 1957. These same United Nations bankster thieves create the fictitious war on drugs and a war on illegal immigration and a war on terror and a war on anything else I can think of, all of which is really wars on we the people to justify their hired thugs at the border and to further make business for their kangaroo so-called courts and to make business for their bankster owned and operated prisons.
That is so true. You're in Texas. Wow.
These de facto kangaroo United Nations courts make sure they get a conviction so they can make business for their bankster owned and operated de facto prisons. These de facto kangaroo United Nations so-called courts have a conviction rate that's over 97%, and if you do not plea bargain it, they throw the book at you, just like they did to me. They want a plea bargain because it's not subject to appeal. The crimes of bar members are too numerous to list. Bar members have converted our nation from a Christian nation that was intended to be into a nation of hedonists and devil worshippers. They've taken God out of our schools and our courts. The number one export in the United States is entertainment. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument, and that's Downs versus Bidwell, 1901. This is all thanks to bar members. The style of this confederacy shall be the United States of America, as found in the Articles of Confederation, and there's a image of a U.S. passport where it says United States of America. Passport defined. A passport is a written document given to a person or persons by commander of belligerent forces authorizing him or them to travel unmolested within the district occupied by his troops. Passports are issued by the State Department or a similar office in other countries to diplomatic agents and others entering or traveling in foreign countries, which are the same general character as those issued during war. The latter should, when practicable, have a photograph of the bearer attached. And this taken from Rules of Land Warfare, 1914 edition, Passports, Safe Conduct, Safeguards, and Cartels, Chapter 7, Section 4, Article 276, page 100. And there's a silver certificate. Notice it says, the United States of America. And there's a land title, a land patent, says, the United States of America. That's the only places I've been able to find those. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. Nothing can stand against the church. I'd like to see the politician who would try to rule against the church. That's Roman Catholic Archbishop James E. Quigley in the Chicago Daily Tribune, May 5th, 1903. And there's Congress. And there's the Roman fasci around the speaker's podium, and we'll get in a little closer here. There's Congress again, Roman Conquest, 24th of September, 2015. And these four texts, we're going to read these separately. We'll go from this corner over here around. And so then it goes to, the first one is Roman Achaea military staff carried in battle by all Roman commands planted on all conquered nations. That's pointing at the staff right here. That's this text right here. And so that's pointing at this staff. And then now we'll read this staff here pointing at Biden. Devout Roman Catholic honorary degree from Jesuit Scranton University. Okay, so that's Biden. It's talking about Biden, who's sitting right there. And then this is Roman bundle of rods bound to a weapon symbolizing subservient rule under the rule of a single man. And that's this text right here pointing at these fasces, Roman fasci.
And Biden again got those put up, right?
And this is devout Roman Catholic trained by Jesuits, installed first Jesuit chaplain to the house. And that's this text right here pointing at Boner, whatever his name was, the speaker at the time. Anyways, this is another picture. There's that Roman staff that's planted on all conquered nations, and these are the Roman fasci right here.
Well, hopefully they're, under what's his face, Biden, they're probably still there, but
Pope claims you're not Christian if you own a gun. Of course, he doesn't want anybody being able to defend themselves. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal feoffees, to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal feoffee, who was held by the courts of equity. That's under the Roman cult. That then under the direction of the clergy, the Roman cult, to be bound in conscience to account to assesticate use for the rents and emoluments of the estate. That's taxes, folks. And it is for these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. That's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And this is where it's codified at 15 U.S.C. section 44. Corporation shall be deemed to include any company, trust, so-called Massachusetts trust or association, incorporated or unincorporated, which is organized to carry on business for its own profit or that of its members, and has shares of capital or capital stock or certificates of interest. And then it goes through the same definition, but it does not have shares of capital or capital stock. The second definition is the Sesticate Trust. This is at 31 Stat 1432, the legal estate to be the Sesticate use, and at 31 Stat 1230, they presume you're dead. But individuals, when acting as representatives of a collective group, cannot be said to exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights, duties, and privileges of the artificial entity or association of which they're agents or officers, and they are bound by its obligations. And that's U.S. Supreme Court, 1988, citing 1944. The birth certificate creates a Sesticate trust. Many people are getting the birth certificates authenticated by the U.S. Secretary of State, thereby claiming to capture the account with the Treasury. Doing this puts you into international law. This is taken from the Hague Conference on Private International Law, 2nd October 1973, the Convention concerning the International Administration of the Estates of Deceased Persons, Article 22. Says any person who pays or delivers property to the holder of the certificate drawn up and where necessary recognized in accordance with this convention shall be discharged unless it's proved that the person acted in bad faith. And then Article 23 of the same convention, any person who has acquired assets of the estate from the holder of a certificate drawn up and where necessary recognized in accordance with this convention unless it's proved that he acted in bad faith, be deemed to have acquired them from a person having power to dispose of them. So that's legalized theft. Yes, I know. I told you it was going to take a while.
Yeah.
The birth certificate's a fraud. If you participate in a fraud, you cannot claim fraud. If you participate in the fraud, you go into international law. Any fake money in the Sesticate Trust account is international law. This is the Australian Attorney General's letter. Notice the certificate here at the bottom. This is the birth certificate content review. And you go to the next page. I wanted to show the certificate at the bottom. And it says a birth certificate is used to establish identity and enable individuals to establish their rights and discharge their obligations in respect of persons provided by the government and the private sectors. Okay, and so the there we go. 14th Amendment is an extension of national military powers presently used in municipal character and enforced by municipal laws, stretched far beyond their original limitations and enforced by Article 1 tribunals. A place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law of the invading army or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation of conquests. The presence of a hostile army proclaims its martial law. And that's Article 1 of the Libre Code. Article 2 says the martial law does not cease during the hostile occupation except by special proclamation ordered by the Commander-in-Chief. I've never seen a special proclamation or by special mention in a treaty of peace. I've seen treaties of peace, but none of them have said anything about ending the martial law. That's Article 2 of the Libre Code. There's 3 kinds of martial law. There's full martial law. Declaration of martial law is issued. Troops are put on the streets. It's used during wartime. It's used on a foreign country when actually invaded by a foreign power or to put down an armed rebellion. Martial law proper is the law of the armed forces when a captain tells a private what to do, and it's enforced by court-martial. Martial law rule is the law of necessity and emergency, allows the domestic use of martial law powers. It's used during times of peace, can continue for centuries during a military occupation. And that's taken from Ex parte Milligan, U.S. Supreme Court. So martial law affects chiefly the police and the collection of public revenue. Remember, we talked about the taxes fall under a martial law jurisdiction. Whether imposed by the expelled government or by the invader refers mainly to the support and efficiency of the army, its safety, and the safety of its operations. And that's why they want you to wear this New World slave flag. So anyways, my book is Trump. I got a copy of it over here. I was talking about it earlier. It's available on my website. You can also get it on Amazon.com. We're going to wrap this thing up.
Trump is an American patriot.
I think so.
Yep, you bet.
There's Trump with the pimp, or I meant the Pope. No, the pimp. It's the pimp doesn't look too happy with Trump.
No, and Trump is smiling.
In reality, they're not after me, they're after you. I'm just in the way.
Yeah.
Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, more properly called municipal law. To distinguish it from the law of nature and international law, that's Black's 4th edition. Let him who will be deceived. That's the Roman law maxim, that they lie, cheat, steal as much as they can. They're nothing but Satanists. The Texas Rules of Civil Procedure right there, and so it's all meant to deceptive.
And no wonder those things were on the wall at the...
I need to keep moving. I got a lot of material to cover.
Okay, sorry.
If a man be found stealing any of his brethren of the children of Israel, make merchandise of him or selleth him, then that thief shall die. And thou shalt put evil away from among you. These bar members are responsible for all of this stuff, and they need to be put to death. Penitentiary has meant a penitent, an ordainer of penitence, a place for penitence. That's what a penitentiary is. And so that's all tied to the Roman cult. Penance is a punishment imposed for a crime by the ecclesiastical laws. It's an acknowledgement of the offense. Penance may be changed into a sum of money to be applied for pious uses, called commuting. And that's Trump commuted Roger Stone's sentence. Well, he paid off the Roman cult is what he did. And that's citing Jacob A. New Law Dictionary, but they're citing Book 3 and Book 4 of the Institutes and the Laws of England, which goes back to the 1500s by Coke. Under the international law of warfare, all parties to a cause must appear by non rigueur because an alien enemy cannot maintain an action during the war in his own name. A mixed war is one made on one side by public authority, the other by mere private persons. Pecuniary cause, such as arise either from the withholding of ecclesiastical dues or neglecting some act relating to the church whereby some damages accrues to the plaintiff towards obtaining satisfaction for which he's permitted to institute a suit in spiritual court. Such, for instance, are the subtracting or withholding of tithes from the parson or vicar, the non-payment of ecclesiastical dues to the clergy as pensions, mortuaries, compositions, and the like. So that's why there's people leaving Europe in droves in the 16s and 1700s, because they were getting away from this crap. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime against its laws. The noun penalty is defined forfeiture, to be forfeited for non-compliance with agreement. The words forfeit and penalty are substantially synonymous. A penal action is one founded entirely on statute and brought with the sole object of recovering a penalty or forfeiture imposed for punishment for a specific offense, while remedial action is one brought to obtain compensation or indemnity. A penal action is an action on a penal statute, action for recovery of penalty. Okay, so this is all tied to the Roman cult, where an action is founded entirely and bar members. Okay, all tied to the Roman cult and bar members. Where an action is founded entirely on a statute, the only object of it to recover a penalty or forfeiture, such action is a penal action. Penal action is a civil suit brought for recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions, on the one hand closely related to criminal prosecutions, on the other for private injuries in which the party agreed may by statute recover damages. Assumpsit in its origin, and so this is all a quasi-criminal is what it is, a quasi-contract is what it is. Assumpsit in its origin and action of tort, assumpsit was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract, based at first upon an express promise, as it was afterwards supported upon an implied promise, and even upon a fictitious promise. Introduced as a special manifestation of the action in the case, it soon acquired the dignity of a distinct form of action which superseded debt, became concurrent with account. So they're talking, these are all commercial terms. Okay, upon a bailment, warranty, bills of exchange, and competed with equity in the case of essentially equitable quasi-contracts. Okay, so this is all talking about martial law, because under martial law, equity can do anything they want. Both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were, they being contractual law, but not in fact, being the subject of a fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it. It is well settled rule of law that he seeks the burdens of contract must also assume the burdens. Yeah, right. That's these Satanist thieves is what they are. Voluntary acceptance of the benefit of a transaction is equivalent to consent to all obligations arising from it so far as facts are known or ought to be known. The person accepting a quasi-contractual action presupposes acceptance and retention of a benefit by one party with full appreciation of the facts under circumstances making it inequitable for him to retain the benefit without its reasonable value. You know, prison's a benefit, eh? Quasi-contracts are based solely upon the legal fiction of the law. It's impossible without the Sesticate Trust. They have to assault you with the Sesticate Trust. Governments, I think I read that one already. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us. And that's taken from the Causes and Necessities for Taking Up Arms, 1775.
Yeah, that was written by the same guy who did Common Sense, Thomas Paine.
Might have been.
Thank you, sir. This is wonderful. I wish we could do this for 2 different times. I've got to go join them.
Okay. Well, we're almost done anyways. But the fearful and unbelievable and murderers and whoremongers and sorcerers and idolaters and all liars shall have their part in the lake which burneth with fire and brimstone, which is the second death. Ye are the father of the devil, a lustier father we will do. He was a murderer from the beginning and abode not a truth, because there's no truth in him. When he speaketh the lie, he speaketh of his own, for he's a liar and the father of it. Bar members are liars, thieves, and murderers. Bar members know exactly what they're doing. Under moral, Albert Pike, who was a Grand Master of the Freemasons, in his book Moral and Dogma, he basically says that Masons are all worship Lucifer, and so they're Satanists, is what they are. Is there any wonder why Christ had such complete and utter contempt for the attorneys of his day? And that's it.
The non-ratification of the 14th Amendment, is that, do you have it in hard copy or is it on video?
It's digital.